I thought I'd start off by saying a little bit about why I wrote the book. Much of my previous work looked at women and Irish politics from the late 19th century onwards, and that included looking at Anglo-Irish women's use of political patronage. The latter involved reading a lot of family-based archival material, and that was correspondence, memoirs, and diaries. And at times, that material would comment at length on the state of a marriage. It also became very apparent that infidelity was neither uncommon nor a solely male pursuit. Some couples undoubtedly endured marriages that were clearly very unhappy. And the question that I had looking at that material was seemingly simple. It was why they didn't divorce. And that seemingly simple question took over 8 years to unravel in the Irish context and led to the book Irish Divorce: A History. This is the first full-length history of Irish divorce, as Liz mentioned. And in some ways that's surprising, because until the middle of the 1960s, the study of divorce in Europe was rare, even though the act itself was becoming increasingly commonplace. Geographically specific studies and some comparative work was produced from the 60s onwards, and that often foregrounded the intersectionality of the state, the church, and society. And that triangulation really provided a model for me in trying to put together Irish Divorce: A History, which, as Liz mentioned, has a big, wide chronological span. And I also soon learned that popular knowledge regarding the availability of divorce in Ireland was also often lacking. This is just a quick quote from the Dean of Dublin's Christ Church Cathedral, Harry de Vere White, and he wrote in 1913, and I quote, "There was a mistaken common notion that Irish marriages are absolutely indissoluble." And so what I was faced with was academic neglect and also a lack of understanding. And I do think both of those are in some ways surprising, because some Irish divorces established legal precedent and generated very considerable comment in their wake. We also see very extensive coverage of divorce in the press. That's because many of the petitioners were upper class in background and their names would have been popularly known. The nature of the evidence that had to be presented to divorce was also often salacious, dealing with sexual impropriety. We also see individual cases regularly being published. So in many ways, divorce is quite hard to ignore. Ireland's divorce division was also often at variance with the liberalisation of family law that we see coming in much of Western Europe in the modern period. So there's a very distinct history that had to be written here. And I then tried to find some comparators, thinking, where can I compare Ireland's divorce provision to? And that was not without issue, that was tricky. But we can look to France, perhaps, where the code that we see for divorce by mutual consent being granted in 1792, that was curtailed a few years later by the Civil Code of 1804. We can also look to Japan, albeit at a later period, but to another restrictive civil code, this time of 1898. But I wasn't expecting to be finding Japanese parallels when I started this history. It's pretty rare, I think, in Ireland's history to find those. So in many ways, the cover of the book, which you can hopefully see before you, which is a painting by the brilliant Irish artist Rita Duffy of a marriage ceremony with the faces blanked out, seemed like a perfect match for a history where so much had been obscured, where we didn't have the names, never mind the faces of Irish divorcees, and also where divorcees were at times written out of family histories. Such was the stigma that surrounded divorce. I was also really interested in writing the book to think about what divorce history might reveal. And here I was influenced by an early 19th century historian, S.B. Kitchen, and he described the history of divorce, and I quote, as a landmark in the history of freedom. And that really struck me. And this book really engages at length with the idea of personal freedom versus state strictures. And I never wanted to lose the human side of divorce for those going through the process, but also those who are unable to divorce. Divorce also sheds light on some of the most hidden aspects of lived experience, marital relations and their associated gender dynamics, for example, a changing definition of marital cruelty, what women should tolerate within marriage, as well as men's spousal duty. So this is a highly gendered history because it's a highly gendered law. And I'll talk a little bit more about the laws we move through. But there were many means to escape a marriage: separation, nullity, bigamy, desertion, spousal murder, migration, just to cite a few. And migration became known in the middle of the 20th century as divorce Irish style. You know, people would just, sometimes by consent, move, sometimes not very far, sometimes across the Atlantic. But interesting, think about strategies that people use to divorce. But if we move on to our next slide, it's to give it its formal title, Divorce of Vinculo Matrimony, which is divorce from the bonds of marriage. That is the only way to end a marriage whilst a spouse was living and enable remarriage. And the history of full divorce, which we might call it as a shorthand, inevitably dwells on marital malcontent and misdemeanors, but that should not obscure the longevity, stability, and happiness of countless marital unions in Ireland as elsewhere. But the book also reveals that many remained in marriage because they lacked the financial, moral, and at times legal means to pursue its termination. One of the challenges in writing this book was to navigate the legal process. And I'm not legally trained, and that was not without its difficulties. But actually, in hindsight, after battling for many years through the legal process to try and get a full understanding of it, I think it really gave me an insight and an empathy into how those seeking to divorce might have viewed and understood what was a very complex process. I don't think the process is well known, so I'm going to spend a little bit of time just running through it, as briefly as I can. And I'm happy, as Liz said, to take questions later on. So the first stage, which is just noted in the first box on the slide, is securing a parliamentary divorce, because divorce through much of our period is a parliamentary process. Certainly the first Irish divorce brought in 1701, and that's a process that continues into the 20th century for Irish petitioners. But this first stage was bringing a criminal conversation action. Now, this was a suit which only men could bring. Husbands would bring this against their wife's lover in the common law courts. And I think criminal conversation is one of my favourite terms because it's just a cloaked term for adultery. So that's the conversation. It's not an oral exchange by any sense. It refers to an adulterous action. It was popularly abbreviated to CrimCon, and the suit develops in the late 17th century, but it's got a much longer tail than that, we think, dating back to 13th century cases for trespass and ravishment. And it's trespass which is the strongest inheritance from these origins, because husbands were compensated for damage caused to their legal property, their wives. Married women were deemed as spousal property, and as a result were barred from bringing these suits. They couldn't offer a defence or present evidence, although the latter was allowed after 1869. And in finding that out, because I wasn't aware of that when I started the book, it seemed progressive. I thought, great, women can contribute now to this legal process. But then I looked at the legal reaction to this and soon found that placing a woman into a witness box to declare her own shame and by her own evidence carry the case in favour of her husband was described by legal commentators as, and I quote, most painful. So I think always just have to keep your eyes open and not go with that first reaction, because it may not be correct, as mine wasn't in looking at this first of all. Criminal Conversation Acts required proof that a sexual act had occurred, and that evidence was often presented by servants, and these cases attract a lot of attention. The damages awarded to husbands in these actions confirmed that not all wives were considered of equal value. Irish awards of damages range from a farthing to £20,000, and say the Irish damages are amongst some of the highest awarded, which I think is an interesting comment on the moral climate. Class was a key consideration in determining damages. So women from respectable stock would get higher damages because it was the loss of monetary wealth, fidelity and consortium which were measured. Ireland's use of the criminal conversation suit was also increasingly at legal odds with the rest of the UK. The suit was abolished in England, which includes Wales in its jurisdiction, in 1857. By comparison, criminal conversation survived in Northern Ireland until 1939 and in the Republic of Ireland until 1981. And you heard me correctly, 1981. I had to double check when I first uncovered that. And in the Republic of Ireland, it was far from a 19th century relic. This act was used and with some regularity. So that's our first phase, criminal conversation suit having to be brought to proceed for a parliamentary divorce. The second stage is a separation, and you can see its formal title there, Divorce Mensa Toro, which is simply divorce from bed and board. From the 12th century, it was the ecclesiastical courts of the Anglican Church which granted this fault-based form of separation. It allowed the parties to live apart, but not to remarry. Grounds for both men and women were cruelty or adultery, but there were additional female grounds. And that was the rape of a party outside of the marital union, because rape within marriage was not illegal until the 1990s, or unnatural practices. And here we're referring to sodomy or bestiality, rarely, if ever, brought in the Irish case study. Evidence was submitted in writing for these hearings, which were considered not by jury, but by ecclesiastical lawyers. And sources are scarce, particularly in Ireland, where the destruction of the Public Record Office in 1921 really caused devastation on our historical record. But from what we know, it seems that some Irish Catholics and dissenters were using the ecclesiastical courts to separate. So it's not just an Anglican practice. Separation moves beyond the Irish ecclesiastical court system to the civil court system in 1869. That was after the disestablishment of the Church of Ireland. But its grounds don't really alter after that. So it's still church law underpinning the grounds for separation, even though it's a court process. And while separation provided salvation for some, for others it was a legal halfway house, because you could not remarry while your estranged spouse lived. The final stage of parliamentary divorce was the introduction of a private divorce bill. So you needed to go through these two earlier suits before you proceeded to Parliament. Until the Act of Union of 1800, Irish petitioners could present a divorce bill to Westminster or to the Irish Parliament. Some very determined divorcees, not getting the result they wanted in one of those assemblies, at times would proceed to the other. So this was potentially advantageous for Irish petitioners. The Irish Parliament passed 11 divorce bills in its lifetime up to 1800. So the numbers aren't huge, and we can make the same point for petitioners in Westminster, Irish and otherwise. Our divorces average about 4 a year for much of the 18th and early 19th century. Parliamentary divorce was a really lengthy process. It could take months, often 9 months, to secure, or it could be delayed by years if the whereabouts of an errant spouse was unknown, or if there were insufficient funds to finance a bill. And that brings us to the question of cost. This was a hugely expensive suit. Costs range from £200 to £50,000, and although an estimated half of parliamentary divorces cost less than £500, this is the equivalent of £30,000 in today's values. So it was rightly described as providing a way to escape marriage for those who were wealthy, and that often entailed a title as well for much of her period. The grounds for divorce also provide one of the most striking and long-lived examples of the sexual double standard, and I deal at length with this in the book. The sexual double standard, like so much of this history, has a very long tail. It was inherent in early Roman law, whereby a wife was regarded as her husband's property, and we can see that creeping in the criminal conversation action, for example. Canon law also categorised a wife as subservient to her spouse, and so a husband's evidence, and I quote, was generally preferred to hers. She was described as practically without remedy. Adultery on the part of a wife was sufficient for a husband to divorce. and was popularly believed to bring a wound which was described in the early 19th century as the most painful and incurable that human nature knows. By comparison, a husband's adultery was an insufficient ground for female divorce. A wife was widely believed to have, and I quote, no right to inquire into the conduct of her superior, whom she ought to presume to be chaste. And this is really significant. A woman had to prove aggravated adultery, often referred to as double offences, on the part of her husband to divorce. So in essence, we have one law for men and another for women in regard to divorce. A woman, therefore, had to, and you can see the grounds specified there on the slide, which I hope is helpful. But here we're looking at adultery plus something else, so plus incest, bigamy, or cruelty. As in separation suits, the rape of a party outside of the marriage and unnatural offences constituted lone grounds for female divorce. Adultery with desertion of at least 2 years duration was introduced as an additional ground for divorce in 1857, but we don't see this being applied in Parliament until later in the 19th century. The impact of these gender grounds is really striking. Just 4 English women and no Irish women divorced in the period up to 1886. The sexual double standard also meant that the fate of divorced women was often trying. The female rate of remarriage was, for example, lower than that of their former spouses. Up to the 19th century and beyond, wives who were divorced normally lost custody of children, and marriage settlements were often significantly reduced. By comparison, male divorcees, and at times men cited as co-respondents, often retained or secured election to both the Irish and Westminster parliaments, for example. So again, how society more broadly reacts to male and female divorcees is very stark. The impact of the sexual double standard doesn't prompt a reform of divorce law, however. Rather, the motivation for this lies in the cost of the process and the unwelcome publicity it engendered. So there were concerns that there would be some moral outfall if something wasn't done to curtail these stories of divorce and adultery, which were peppered throughout the press in both Ireland and England. The reform comes in the shape of the Divorce and Matrimonial Causes Act of 1857. And that moved separation and divorce in England to a court-based process, and one we'd be much more familiar with today. This brought England closer to Scottish provision, which had a court-based process of divorce from the time of the Reformation. But Ireland was excluded from the 1857 Act. And so the system of parliamentary divorce, which is highly criticised and rightly so, endures for Irish citizens. And this placed Ireland in an increasingly unique position in the empire. Canada, Australia and India, for example, moved to court-based processes of divorce based on the 1857 Act and with the explicit encouragement of Westminster. And so we see a position emerging that by 1869, only Irish divorces were routinely being heard in Westminster. And despite the restrictions and the expense of the system of parliamentary divorce, 92 Irish Divorce Acts were passed from 1857 to 1922, with a steady increase evident in the early 20th century. And some of the rationale for the increasing number of Irish divorces being passed in Parliament lies in the impact of a landmark Irish Divorce Act. This comes in 1886, and Louisa Westrop became the first Irish woman to secure parliamentary divorce. Her act establishes legal precedent. And I have no image to show you of Louisa Westrop. I have never seen her face. And I've been through family histories and so on, and there's no mention of her. So I think she is very much written out of that family history as a result of this divorce. I do know something of her background. She was of landed Irish stock. In 1878, at the age of 19, she married her first cousin, Edward Morgan, who was from Limerick, and that takes place in an Anglican ceremony. And within 3 months of that union, great cruelty was alleged to have commenced, to quote from the legal record. 3 daughters were born, but frequently intoxicated and using what was described as violent and indecent language, Edward would spit in his wife's face when, and I quote, sober by way of amusement. He forces his wife into a stable with loose horses. He points a loaded revolver at her. He threatens to shoot her. She and the children were hit, and I quote, with a whip until the blood ran, and the 3-year-old child was beaten in front of her. Louisa Westrop lived, and I quote, in bodily fear of her spouse, and her health declined. This, coupled with Edward's adultery, led to an informal separation in 1883, and 2 years later they formally separated due to spousal cruelty. And it's indicative of the severity of her abuse that she was given custody of children. Previously, such abuse would have been insufficient to procure a parliamentary divorce. Because life and limb was deemed to be required, to be under threat for marital cruelty to become a ground for divorce. So it is really cruelty of the most severe kind. But the severity and type of marital cruelty was successfully being challenged in the divorce court in existence, as I've mentioned, from 1857. And in Westrop's case, Parliament decides to follow that lead, which is emerging in court. And this establishes the Westrop principle, or the Westrop precedent, which held that any ground for divorce accepted by court could be applied in Parliament. And this is hugely significant to Ireland's divorce history, because what we see after Westrop's case in 1886 is women starting to come forward to Parliament to try and divorce. So 5 Irish women divorced in Parliament in the remainder of the 19th century, and a further 24% bills from 1900 to 1922. The impact of the Westrop precedent, I think, is nowhere more apparent in saying that female bills were in the majority from 1914. These divorces were mostly brought on the grounds of adultery and cruelty, but desertion of 2 years, because it was a recognised ground for divorce in court because of the 1857 Act, was also cited as a ground for divorce post-Westrop. So a really significant case, and I hope one day to see a picture of Louisa Westrop. That would be fantastic. The female petitioners who are following Westrop include the first Irish Catholic to divorce in Westminster. That case comes in 1905 and involves Alice Donovan, who was from Cork, and she, like Westrop, was divorcing on the grounds of adultery and cruelty. She had married in 1895, and within a few years her spouse, and I quote, began to use violent language and frequently was guilty of various acts of cruelty. She ceased cohabitation, her spouse was adulterous, and her husband then admits, and I quote, "Yes, I did this, but I now ask for forgiveness for having done so." So Catholic divorce, I didn't know if I was going to find any. I didn't find too many, but I found some. And again, I think that really helps widen out our understanding of who is actually divorcing. And it's not just Anglicans, although they are in the majority. Although the grounds for divorce were affected by cases like Westrop's, a number of Irish citizens also tried to divorce in court where they shouldn't have been. And I think that indicates just how difficult the parliamentary process of divorce that Ireland was stuck with actually was. Divorcing in court was cheaper, it was faster, and there were 3 cases before the new court as early as 1859. But many of these cases were surreptitious. Homes were taken and rates were paid in England to try and prove English residency. This was not to be lightly entertained. A covert court case could invalidate a second marriage, so he could be accused of bigamy. Children could be bastardized, marriage settlements contested, and that could lead to a divorce bill being presented in the very venue that petitioners had tried to bypass Parliament. Subsequent legal challenges could also come years after the court divorce decree. Partition and independence for 26 counties of Ireland in 1922 saw the newly created Irish Free State attempt to rewrite its earlier history of divorce to the extent that its existence was at times denied. There was no provision for divorce in the new state, and that position was confirmed by the 1937 constitutional ban on divorce. By the late 1970s, it was clear that Irish marriages broke down with an increased regularity, despite the constitutional ban on divorce. And in many ways, that ban created an illusionary portrayal of family stability, when really the ban could never control private lives. Divorce reform began to be mooted, but was often described as a destructive, liberalising force that could subvert society. Two very spiky referenda held on Irish divorce reform in 1986 and 1995. And although they fall a little short of, and I quote, the sectarian bear pit of W.B. Yeats's imaginings, the latter's poll was so close at 0.6% in favour of removing the constitutional ban on divorce that a recount had to be held. And this little cartoon by a brilliant cartoonist, Helen Shea, maybe gives just some indication of how things were being portrayed at a popular level. And so this little cartoon from The Independent was highly controversial. Shea was accused of blasphemy, albeit unsuccessfully. But divorce was really seen as something that could change the complexion of Ireland forever, and it was hard fought. Divorce reform in Ireland was often described in apocalyptic terms, invoking floods and deluges, but moral conservatism and concerns about cost kept divorce rates comparatively low in the Republic of Ireland. So we usually see about 3,500 annual divorces being granted per year. Sometimes that's a low European rate, sometimes less so. The divorce rates were always higher in urban areas, especially in Dublin. And interestingly, we see the female majority in divorce petitioners previously evident in Westminster from the late 19th century also emerging. By comparison, the new six-county Northern Ireland state in existence from 1921 adopted the parliamentary system of divorce. And again, when I started this project, I had no idea that they had done this. And it is in many ways shocking because everyone knew that the system of parliamentary divorce was, really very, very difficult, public, expensive, long, all of those things we've touched upon, but Northern Ireland adopted. And I think that's very easily explained. It was indicative of a characteristic dependence on Westminster for legislative inspiration and a perennial fear of making divorce easy. And this little American cartoon from Puck, which is the American version of Punch in many ways from the interwar period, shows what's feared, this idea that divorce will be so easy that, when you stop off to catch a train, you can divorce. Of course you can't, but I think it really just gives an indication of that. The Parliament of Northern Ireland heard and passed 63 divorce bills up to 1939. And the majority of petitioners were Belfast-based, so that urban complexion re-emerges in the north of Ireland. The largest proportion of petitioners were married in Anglican ceremonies, and this was the only denomination whose divorce rate exceeded their demographic representation and continues a trend which was evident from the very start of the system of parliamentary divorce. Although this profile was underpinned by the higher social status of many Irish Anglicans, the 1908 ruling of the Lambeth Conference that innocent divorce parties could receive communion after a civil marriage began to lessen the stigmatisation of divorcees in at least one denomination. Of the remainder of those Irish, Northern Irish divorce petitioners coming through the Parliament in Belfast, 21% were Presbyterian, 3% were married in Catholic ceremonies, and later on that Catholic majority that does start to increase quite significantly. Those divorcing in the Northern Ireland Parliament had a more varied social profile than emerged in Westminster. And that was due to cost. Divorce bills were subject to less delay in a smaller devolved assembly and were in consequence cheaper. £170 was the highest cost of a divorce in the Northern Irish Parliament, and although the equivalent of £10,000 today was considerably less than the average cost of divorce in Westminster. The gender profile that we see, however, has much in common with Irish divorce bills heard in Westminster from the late 19th century, and also with the profile that emerged later in the Republic of Ireland. So 54% of Northern Irish divorce bills heard by the Belfast Parliament were brought by women. Northern Ireland moved to a court-based system of divorce in 1939, a move which England had made in 1857. So they're fairly slow to make this move. There's a lot of caution, and even moving to court in 1939 was based on Westminster's reforms rather than engaging with arguments that had been there from the 18th century that Parliament was not a fitting venue for divorce hearings. As in the Republic of Ireland, moral conservatism and concerns about costs led the Northern Irish divorce rate to be consistently lower than we see in England and Scotland, and that pattern with an average of round about 2,300 divorces granted per annum still survives in Northern Ireland. So, to conclude, Irish divorce was often portrayed as a precipice which could endanger the institution of marriage and social stability. Those who sought its reform, seeking to standardise legal provision throughout the UK and the Empire, or end the suffering that such a restricted and partial law engendered, were frequently considered morally bankrupt. So divorce reform often lacks champions. A fear of unsettling Ireland by introducing divorce was also apparent in successive administrations from the middle of the 19th century onwards. As attempts to break the union by both reason and force forced the so-called Irish problem to centre stage, it was deemed advisable to allow the admittedly flawed system of parliamentary divorce to continue for Irish petitioners. The trepidation of reform that we see when Ireland was under the Union was also shared by those who opposed divorce with an increased ferocity in the post-independence era. So for much of its history, divorce was only available to a minority in Ireland. But as Kitchen noted, it ultimately frees people from unhappy, loveless and abusive unions. Its denial in the Republic of Ireland for much of the 20th century was due to a state balancing act between the common good and the rights of the individual that was often performed to the detriment of the latter. Issues of self-determination, jurisdictional boundaries and state building were regularly deemed of more pressing importance than divorce reform. Moreover, the frequently unacknowledged system of Irish parliamentary divorce allowed the perpetuation of the myth of a morally superior country that had no need for divorce. This gave the opponents of divorce in both the north and south of the country a moral high ground from which to purport an exceptionalism which did not reflect the complexities of marriage in modern Ireland. The history of Irish divorce, however, counters the veracity of these claims of exceptionalism, and in restoring divorce and the life histories of divorcees to the Irish historical narrative, it's clear that both husbands and wives strayed from the marital bond and experienced many of the same issues that tried couples elsewhere. Thus, although various methods were deployed to counter the inaccessibility and at times unavailability of divorce, it afforded the only means for a permanent release from the bonds of marriage to allow remarriage, freedoms which were so long denied to many of Ireland's citizens. Thank you.
Thank you, Diane, for that wonderful talk and for a whistle-stop tour of the history of Irish divorce, which I'm sure would have inspired many people to read the book. So I hope please do get hold of a copy of Irish Divorce: A History for the full story. Please do submit your questions through the chat box if you have any. I'm just going to start off the discussion because I'm sure there are lots of things arising from that. But just to ask you, Diane, what you found in the course of your research for this book over, I think you said 8 years, what was the most surprising thing that you found, and what do you think will be most surprising to your readers?
Thanks, Liz. I think it's the gendered nature of actual divorce law. I had an indication, because I teach both Irish and British history. I'd looked at a lot of feminist campaigns previously, and I knew there'd been, some moves to try and reform divorce, but it was really engaging with that and then trying to think through, did it matter? It's a question I ask all the time when I'm researching to try and understand the impact of that. And then, realizing that no Irish women had tried to divorce, in Westminster up to 1886 seemed just extraordinary, because people were definitely having problems and there were adultery on both sides. There was abuse, there was desertion, the list goes on and on. So I think it was really just the extent of how highly gendered this law was and then how long that was allowed to go on for. And as I say, then seeing how Ireland started to really pull away from the experience of the rest of the UK was challenging again to try and really engage with that fully. But yeah, it was those two things, sort of Ireland's exceptionalism, not on a moral point, which was talked about much more at the time, but really on that gendered side. And I devote, quite a lot of time in the book to really looking at that and thinking about how that changes and, uncovering. I mean, Louisa Westrop's precedent was totally unknown to me when I started. And I did find some contemporary references and even some spanning well into the 20th century, which did acknowledge her importance. But those sorts of things are always a joy to find, and I'm really happy to restore her to her rightful place, because she was immensely brave in bringing that forward.
And so, I think one of the great strengths of your work is the way that you give life to these, the individuals behind the statistics and the sort of potentially dry legal history. Is she? So would you say that she's your favorite divorce case, or which story touched you the most?
There were a lot. I mean, one of the challenges, Liz, in actually writing this, because I had to read, case after case of marital cruelty, was not to become in any way desensitized to that, and to always remember that each of these cases is not just a life, but thinking about how divorce impacts in a family setting. It reverberates through a very wide, friend and also family network. So although I'm very, very fond is maybe the wrong word, but I do have a great sense of admiration for Louisa Westrop. One of the cases that touched me the most, and anyone who's read the book might know what's coming, but there's a case of Marianne Talbot, which comes at the tail end of the 1850s, so just before the reform for England was coming to move separation and divorce to a court-based system. And this really exposed so many of the flaws and vulnerabilities of women under the existing law, because she was essentially set up by her spouse, and was subjected to some kind of physical and likely sexual attack at the hands of servants. The servants were paid for their testimony. Marianne Talbot never regains her sanity after this and ends her life, in family care and often in institutional care. But still, they were willing to go through numerous of cases and take this to a parliamentary divorce hearing, which was passed. And some people were aghast. Her brother-in-law is Paget, and Paget's a really renowned and really gifted barrister. He then runs with her case and writes extensively about it. The press is on board as well, so she's seen very much as the victim of this, and people are saying, being critical not just of parliamentary divorce, but also at that time of the system for hearing separations. And as I mentioned when I was talking, that's not by jury, it's by ecclesiastical lawyers are making the decisions. It's not calling witnesses, it's just looking at written testimony. And people were just saying this cannot go on. And then some of the papers say that reform would, rescue Marianne Talbot from her misery. And I don't think that's right, because her life was ruined. And then there's, really I find very moving accounts of her, sitting in a very docile, subdued state, just crying for her child who she was separated from. So favourite is maybe not the right term. And I have been asked this question before, Liz. And it's interesting because it really made me think. But that really helped me understand why the law needed to change, and how it could really affect people's lives in the gravest of ways. And so again, happy to restore that horrendous story to the historical record, because it was so illuminating for me, working through it. And a lot of people did comment on it at the time, and then things just get lost. And I say this history really just hadn't been looked at. So the sources were fantastic, which really helped there as well. But no happy ending in that one.
And you mentioned there the number of cases and the fantastic sources that you were working with, and I just wondered if you could say a bit more about the sources, how you found them, and how how you worked through them, how you decided to draw a line and to complete the book.
Yeah, it was a very mixed source base, and initially when I was looking at it, Liz, I was thinking, gosh, why hasn't this history been written? Because I was finding sort of a lot more material than I was initially expecting. I mean, the press was full of cases, often in great detail, because there was no regulation of the press producing this type of material until the 1920s in both England and Ireland. The Irish legal cases, some things just hadn't survived, certainly for the earlier period. But I looked at the parliamentary material was fantastic, and often was telling me a lot about those prerequisite suits which I mentioned. So criminal conversation and separation suits, they would get that evidence as well. And I looked at a lot of family papers that say sometimes there was no mention what divorce was kind of what I was scribbling down in notes when I was working in the Public Record Office in Northern Ireland, for instance, thinking there was just no mention of it. But this has obviously been a process maybe of editing in the familial record and removing anything that was deemed unseemly, as divorce often was. So I mean, I'm very interdisciplinary in the way that I work, so I just didn't really have anything that was off limits. And I say, because I didn't have legal training, I had to read a lot of legal material, which was slow, at times a little frustrating, but I think in the end gave me what I needed, which was an understanding of how this law, actually worked. But I still think there's sources. I mean, something I might go on to do is to do a little bit more on sort of life post-divorce, to think about how people got on, because I've got an indication of what happened, but I'd like to dig a little bit further. So that would be more family-based archival work. And our archives are slowly opening up at the minute, after being locked down for a few months. So that might be something I look at again. Liz, I can see a question's come in from Patricia. I don't think anyone else can see the question. So Patricia, I'm just going to read out your question and then I shall try to answer it. So Patricia's asked, did people in Ireland with houses in England gain a divorce that may seem to be an English divorce? So yes, they did, Patricia, and some people did where had English residency, so they may have been born in Ireland, and so some can legitimately go to the court once it's there, from 1857 onwards. Others, as I mentioned, are using various strategies to try and access the divorce court, for a cheaper divorce and a quicker divorce. We still get a lot of press coverage of court-based divorces, but it's just not as explicit as we see in Parliament. So some people say do this rightly, other people less so. And Patricia's also asked about did people follow such divorce cases for gossip? And yes, they did, and some cases are published separately as sort of little short pamphlets, and I think that indicates, that there's an interest in the area. Earlier on in the 18th century, I think these serve sort of a dual purpose. They're sort of a warning to people, if you stray from the marital bond, this is where you might end up. But they're so detailed. I mean, really nothing is off limits, because you needed evidence that an adulterous act had actually occurred. So that brings servants into the fray, and it's such an interesting class dynamic. So servants often bringing quite damning testimony against their employers, and there's much talk of rumpled sofas and hotel registers, the people masquerading as husband and wife are presented as evidence. Later on we have photographs, and so on. So there's a lot of I think notoriety that really surrounds divorce. And so yes, definitely people did follow such divorce cases for gossip. And Patricia has also asked, thanks Patricia, would solicitors' collection be the main source in Ireland? I wouldn't say the main source, Patricia. I mean, I think if you were going to do some work in this area, I would say try and define what period you want to work on. And I would look at the press, first of all, because that will give you, nice short leads, and it has the benefit of mostly being searchable online. There are some really notable solicitors who bring, a majority of cases, and I do talk about them in the book. Some have left records, some haven't, so it can be a little bit patchy. But as I said, in Ireland, we're often struggling with what we lost in 1921. So it can be, a difficult record to really get a gauge for. But as I say, I would never rule anything out. But, church records can also be, very insightful. Reading in papal encyclicals, they're all online. That really helped me at certain points just to navigate this, to think about what's going on. Because one of the most useful things that I read quite early on was the law reflects society. So if the law is being challenged and, and it's a very fluid mechanism anyway, that often means that there's a cultural or social shift happening. So sometimes looking at church records will allow you to pick up and become sometimes clearer. Trish, I hope that's answered your question.
I think so. Please do keep sending your questions in. Another question from me. So the book, Diane, is about the exceptionalism of Irish divorce, and you spoke very interestingly in your talk about some parallels with some Japanese examples, very surprising. And I wondered if there's anything more that you felt able to say about that, about the sort of how the Irish experience of divorce fits into that sort of broader international context, and also whether that exceptionalism, whether you see that continuing now, or whether that's whether the Irish experience is less exceptional now.
Yeah, it was hard to find parallels, Liz. It really was. And what I didn't want to do was sort of just, accept what, a lot of the sort of moral protagonists were saying, that Ireland is exceptional. There's a lot of romanticised talk. Even Gladstone falls prey to this at times as well. So I wanted to question that, because I thought, well, look, not everyone can be happily married. First of all, so from starting to there, I started to look more broadly, and but it was really tricky, and I think possibly it sort of picks up on a point I was making in response to Patricia's question a couple of minutes ago. It's just how fluid the law is, and what we don't see in Ireland is this notion of a progressive, steady process of liberalism, so reform following reform. That moral conservatism in both north and south of the country was so embedded, and to an extent still is, that there was often a backlash. So even if we had a reform, then it would be challenged, or you would see then a move coming in another direction. And I think a lot of Irish history is maybe moving in a similar direction. So we used to talk an awful lot about De Valera's Ireland, for instance, as shorthand for independent Ireland. And sloppy though it was, it probably did the job. We don't use that term so much now, because we're looking back to that new state in its earliest incarnation in the early 1920s, and also looking beyond De Valera and thinking, what has changed? And then also looking at the north of the country and thinking, well, that conservatism was not just a Catholic stronghold. Many of the Protestant churches, were on the same page. And that might be one of the surprises for people reading the book, is to think about, this isn't just a Catholic story. And I think that has surprised people. I know from doing events like this and, presentations, that sometimes people are surprised at just how much common ground there is between the churches. So that's one thing. On that international frame, I think, we could look at Italy, for example. So Italy was quite, late to divorce, and again had a very patchy process. And it was, in many ways, some of the Italian protests made the Irish protests in the 20th century look quite tame. So that was, interesting to look at, to try and get a grip of really what was happening in Ireland. It was also interesting looking at the Italian divorce reform process, to think about where were feminists because often they are very lacking in this reform process. So we see that in Ireland, we certainly see it in Italy. It's not really on a feminist agenda until quite late in the day, and sometimes if at all. So first wave feminism, from the 1890s onwards, just wasn't engaging with it. And there were some great quotes from amazing women like Nell McCafferty, the Irish feminist, said, about her experiences in the 1980s in Ireland, that it just wasn't on their agenda. And in hindsight, she suggested that was due to naivety on their part. But I think it's also a comment on how divisive divorce was. So if you're trying to get a big reform movement, you maybe are shying away from things that are going to split people. Now, they did talk about lots of contraceptive reform, abortion and so on. There were lots of divisive things in that agenda, but divorce really isn't that high up the scale, which was interesting. So looking outside of Ireland could help just measure what was going on. And I think there's a lot more comparative work could be done. As I say, so this is the first history of Irish divorce, and hopefully that will allow me and or others, maybe collectively, to sort of start to incorporate Ireland's history into a broader Western European history of divorce. But often Ireland isn't going to be a neat fit at all. But it was really important for me, just to try and understand what was going on, and also think about, European influences, joining of what was then the EEC in 1973 and so on. Was that going to impact? So there were bigger questions to ask there. So it was definitely useful, and I think there's a lot more to be done.
Brilliant. Well, you're obviously drawn to, you've written about divorce now and also about abortion, so you're obviously drawn to taboos. So I guess that answers one question. Another question I had about, and you suggested that you might be by looking at the experience of women or of people after divorce as well. So perhaps you've got a lot on your plate for the future there.
I think it overflows, and it was really tricky because often when I do, say, events like this, people want to talk about lots of other things as well as this, full divorce, as I call it, as a shorthand. People want to talk about nullity and separation and bigamy. I understand all of that, but all of those areas have to be still written in an Irish historical context. So I could be busy for quite some time, and I think there's room for a few more people in the field. But I think actually what I'm really going to do next is to look at criminal conversation. So I'm just fascinated by that, and it still exists in some American states. In North Carolina, for instance, still exists, and some huge six-figure damages have been awarded in the not so recent past. So I'm wondering if a little global history of criminal conversation might be on the cards. But again, I just need to look at sources and see what's come in there.
I think you've got another question from the audience. Diane, can you see that, or shall I get somebody to read it to you?
I can't see that one at the minute, so if someone could read that, that would be super.
No problem, I will read it out to you. So it says, great talk, Diane. Did studying divorce over such a long period teach you anything about other gender issues, e.g. attitudes over time in Ireland towards sexual violence, gender-based violence, etc.? From Gemma.
Thanks, Gemma, and thanks for the kind words. And it's a great question. Yeah, it taught me lots. It really did. And thinking, for example, about that changing definition of marital cruelty, why that broadens out, why it moves beyond that very serious, just physical violence, then to include, for example, punishing a child in front of a mother for the express purpose of upsetting her. Verbal abuse, which anyone who works in the field will know, many people who've been through it say is actually worse than the physical abuse because its effects are longer standing. So it really, thinking about why those changes were coming through the law patchily, slowly, I had to then think about how men and women were being viewed within marriage. Companionate marriage had started to emerge quite forcibly, and that's not something I'd looked at in any great detail before. But that really helped me understand. So again, it was marrying what was happening in the legal frame with those cultural shifts. And again, reading outside of Ireland and looking what was happening in America actually was really, really useful, because it's the same thing. It's a cultural shift then informs that legal process. So I think that was really just giving me an understanding of how far-reaching gender is. You know, it was in every corner of this frame that I was actually looking at. So yeah, I learned a lot. I really did, and that's probably why it took so long.